Case number NSCN/LSR348/2019 between Mr. Babatunde Agbontafara and one Polaris Bank Limited, 2 Nigerian Deposits Insurance Corporation.
Hello, gentlemen. Good morning.
Good morning, my lord.
Thank you.
Good morning, my lord.
Thank you. Good morning. So we yes, parties absent or present. Yes, parties absent. Yes, the counsel in the Polaris case.
Respectfully, my lord, I'm
Yes.
A.O. Badibo. I'm holding the brief
E.O.
of A.O. Badibo.
Okay, A.O. Obadibo. Yes, holding
Holding the brief of T.O. Ajayi for the claimants in this matter.
Okay. Yes. Yes. Yes.
Respectfully, my lord, O.A. Adeboale for NDIC.
Okay. O.A.
Adeboale for NDIC.
For the third.
For the second. Yeah, sorry.
Yes. There's any person for the Polaris Bank?
Yes, my lord. NDIC is represented. However, the representative is having network issues.
Okay, it's okay. It's okay. So this is my ruling. By a notice of preliminary objection, NPO, dated and filed on 24th of February 2022, the third defendant applicant is praying for the following orders. Number one, an order of this honorable court dismissing, eliminating defendant on the suit of the claimant, first respondent, as presently constituted on the ground that this honorable court lacks the requisite jurisdiction to hear and determine this suit as presently constituted, and for such further orders or order as this honorable court may deem fit to make in the circumstance of this case. The grounds on which the notice of objection was brought are stated on the face of the motion paper. The notice of preliminary objection is supported by 10-paragraph affidavit. A written address was also filed to accompany the objection, wherein counsel for the applicant submitted the following issues for determination to it. Number one, whether the claimant/respondent suit is not incompetent for the failure to serve the third defendant with the mandatory pre-action notice as stipulated by the provision of Section 55, Sub 2 of the NDIC Act 2006. Number two, whether the claimant has disclosed any reasonable cause of action against the defendant. Counsel for the applicant in his oral submissions withdrew his issue number one and the arguments in support of same. Also submitted that the law is tried that jurisdiction is the life wire of every action filed before the court. And while the court for which an action is filed lacks jurisdiction in any capacity, the entire proceedings of the court and judgment will be rendered void, notwithstanding how well the proceedings were conducted. Citing the case of Umba and State, counsel also submitted that it is settled law that a claimant who makes any claim or relief must support his claim with facts and materials recognized by law, which entitles him to the relief claimed. That this factual situation is what gives the claimant a right of action, citing SPDC Nigeria Limited and XM Federal Limited. That the law is also tried that when an objection is raised that a suit discloses no reasonable cause of action, the documents to examine are the statement of facts and the complaint. Submission of counsel that the first respondents or noting processes disclose no reasonable cause of action against the applicant. Therefore, the action should be dismissed in limine for the reason that no allegation of any employment relationship has been made against the applicant, and that the applicant, though empowered to defend suits on behalf of failed banks, but cannot do so outside the scope of its statutory mandate. To the further submission of counsel that was written process filed by the first respondent do not disclose any allegation of facts that the claimant that the applicant in whatever capacity contributed to this engagement of the first respondent, that the first respondent decision to sue the applicant is a misconceived view because the applicant being a statutory liquidator is not responsible for all claims against a failed bank. That the applicant is a statutory insurance company which was established by law to secure depositors' funds in possession of a failed bank. That the applicant by its enabling status does not acquire the liabilities of the failed banks save from the insecure depositors' funds. That a failed bank is still an existing legal entity which can sue and be sued, such in the case of Oridola Okoya Trading Company and Bank of Credit and Commerce International. Counsel posited that the NDIC is a statutory liquidator of failed banks and thus empowered by Section 40 of the NDIC Act 2006 to settle claims and defend suits on behalf of failed banks. However, its functions are limited to ensuring the deposits of customers in an insured institution as provided in Section 2 of the NDIC Act. It was finally submitted that the applicant is not statutorily empowered to defend suits arising outside the scope of its statutory mandate. And based on the originating processes filed, there is no allegation of fact to make the first respondent entitled to the relief sought against the applicant. The claimant first responded in opposition to the notice of objection, filed a 13-paragraph counter affidavit on the 8th of March 2022 and attached one exhibit. A written address was also filed to accompany the counter affidavit, wherein two issues for determination were submitted as follows. Number one, whether this honorable court can assume jurisdiction over this matter as constituted, and number two, whether this suit is competent. Council submitted that certain factors should be considered in the determination of the course duration or competence. Council referred to the case of EFPC and NDIC. The submission of council that the jurisdiction of the court is determined by the claimant's claim as endorsed on the writ of summons and settlement of claim, citing the case of Goldmark Nigeria Limited and Iberphone Company Limited. Council also submitted that the issue relating to disclosure of reasonable course of action is an issue of law and does not require any evidence, whether oral or documentary, and no affidavit evidence, save the averments contained in the settlement of claim. That this court, in considering the issue of reasonable course of action, is precluded from considering any evidence, whether by way of affidavit in support of the applicant hearing, in support of the application hearing, that the court is confined to averments contained in the statement of claim, citing Order 30, Rule 18 of the rules of this honorable court. Counsel argued that this court should discountenance the affidavit in support of the preliminary objection and hold that there is no affidavit, as the court is precluded from looking at affidavit in support when considering the issue of reasonable course of action. To the further submission of counsel that the claimant has complied with the prescribed requirement of the law and urged the court to resolve the issues raised in favor of the claimant and dismiss the application with substantial costs. I have carefully perused the processes filed by the parties and considered their respective submissions. And in determining the notice of objection, the point I will address is whether the suit filed by the claimant has disclosed a reasonable course of action against the third defendant applicant. I need to observe that the applicant withdrew his issue. The applicant withdrew its issue number 1, which borders on pre-action notice. That issue, having been withdrawn and abandoned, is hereby struck out, and all the arguments of submission relating to the said issue are accordingly discountenanced. It is the applicant's condition that this should be dismissed in limine on the ground that there is no reasonable course of action disclosed against the applicant. Claimant has however argued otherwise. It is tried that a course of action is constituted by the bundle or aggregate of facts which the law will recognize as giving the claimant or plaintiff a substantive right to make the claim against the relief or remedy being sought, that the factual situation on which the claimant relies to support his claim must be recognized by the law as giving rise to substantive right capable of being claimed or enforced against the defendant. In other words, the factual situation relied upon must constitute the essential ingredients of the enforceable right or claim. See the case of Bello and Attorney General Oyo State. In Akilo and Fawehimi, it was concisely stated that a course of action is any act on the part of the defendant which gives to the plaintiff his cause of complaint. Two crucial factors must coexist to consider a course of action before the court. They are the defendant's wrongful act and the consequential damage to the claimant. It does not take account of whether the course of action will succeed or fail. A course of action is valid irrespective of the strength or weakness of the claimant's case. See the case of Idigbe and Agolo. It is tried that in determining whether the claimant's case has disclosed the course of action against the applicant, recourse shall be had to the argument made in the claimant's pleadings. It has nothing to do with the nature of the defendant's defense. This court, as it was submitted, will only confine itself to the argument in the pleadings to assess whether there is a reasonable course of action or not. I need to examine here the fact averred by the claimant in his statement of facts. The relevant facts averred at paragraph 2 of the state statement of facts, which states as follows. The first defendant is a public, I quote, the first defendant is a public liability company incorporated under the Companies and Allied Matters Act 2004, dealing in banking business, with a registered office at number 3, Akin Adeola Street, Victoria Island, Lagos State. The second defendant is a body empowered by law to issue or revoke banking licenses to banks and no insured institutions in Nigeria. While the third defendant is the body empowered with rights to appear in court on behalf of an insured institution, such as the first defendant hearing, whether it bears Main Street Bank, Sky Bank, and or Polaris Bank, and it is empowered by law to render financial assistance to an insured institution, such as the first defendant hearing, whether it bears Main Street Bank, Sky Bank, and or Polaris Bank, empowered to close a failed insured institution, such as Main Street Bank, Sky Bank, and or Polaris Bank, empowered to act as liquidator to an insured institution, such as the first defendant hearing, whether acting as Main Street Bank, Sky Bank, and or Polaris Bank, until the second and third defendants, in consultation with each other, that are empowered by law to incorporate a bridging bank, with the first defendant hearing claimed to be by a statement of defense hearing. The fourth defendant hearing is the body that acted in conjunction with the second and third defendant hearing in acquisition of Main Street Bank, which translated into Sky Bank and now Polaris Bank Limited. Unquote. The above abundant state that the third defendant applicant is the body empowered to appear in court on behalf of an insured institution, such as the first defendant hearing, to render financial assistance to the first defendant, and also empowered to close a failed insured institution and to act as liquidator to an insured institution. Applicant, on the other hand, stated that it is a statutory liquidator of failed banks empowered by Section 40 of the NDIC Act to settle claims and defend suits on behalf of the failed banks. However, its functions are limited to ensuring the deposits of customers in an insured institution as provided in Section 2 of the NDIC Act. Section 2 of the NDIC Act states as follows, and I quote, "The corporation shall have responsibility for A, ensuring all deposit liabilities of licensed banks and other deposit-taking financial institutions, hereinafter referred to as insured institutions, operating in Nigeria within the meaning of Section 16 and 20 of this Act, so as to engender confidence in the Nigerian banking system. Number B, giving assistance to insured institutions in the interest of depositors in case of imminent or actual financial difficulties, particularly where suspension of payments is threatened, to avoid damage to public confidence in the banking system. Number C, guaranteeing payments to depositors in case of imminent or actual supervision of payments by insured supervision of payments by insured institutions up to the maximum amount as provided for in Section 20 of this Act. Number D, assisting monetary authorities in the formulation and implementation of banking policy so as to ensure sound banking practice and fair competition among insured institutions in the country. And number E, pursuing any other measure necessary to achieve the functions of the corporation, provided such measures and actions are not repugnant to the object of the corporation." Unquote. Following from the above, it shows that the function of the applicant are limited to ensuring the deposits of customers in an insured institution as provided in the Act. It shows that its responsibilities are not to defend or assume liabilities outside of those relating to the depositors found in an insured institution. It has not also been shown from the Act that the third defendant applicant has any legal obligation to settle the claimant's terminal benefits. It has no employment relationship with the claimant, or that this suit cannot be completely, effectively, and effectually be determined without the third defendant applicant. I do not think that a body such as the applicant, whose functions are limited to ensuring the deposits of customers in an insured institution, must be made a party in a suit for claim of entitlements. See the case of Chevron Nigeria Limited and Lone Star Drill Nigeria Limited. The fact that the third defendant could appear in court on behalf of an insured institution or under financial assistance and also close a failed insured institution and act as a liquidator to that institution without more, does not automatically make it liable for the action of or inaction of the first defendant. The claimant should prove that the role played by the third defendant in the instance case or the powers conferred on it entitles him to claim for his terminal and redundancy benefits. In other words, the claimant has to prove that the corner of the third defendant has done some wrong to him, a wrong which justifies a relief in law. See the case of Rimco Construction Company Limited and VP Industries Limited. Therefore, I am of the opinion that the amendment made in paragraph 2 of the claimant statement of fact does not entitle the claimant to hearing on merit of his case, given that the functions of the applicant as provided in section 2 of the act establishing it are limited to ensuring the deposits of customers in an insured institution. Accordingly, I do not agree with the panel counsel for the claimant that there is a valid cause of action against the third defendant applicant. In the light of the above, therefore, I am satisfied that there is no reasonable cause of action against the third defendant, and there is no nexus between the claimant and the third defendant on the face of the pleadings or in law, and it should not so remain a party in this suit, and its name ought to be struck out, and I so do. See the case of Olufoyese. So that's my ruling.
Thank you, my lord. We are grateful for the well-considered ruling.
Thank you. Mr. Obadibo. Mr. Obadibo.
Thank you, my lord, for the well-considered ruling.
So what do you do now?
Earlier on.
What do you do?
We'll be asking for a date for trial, sir.
Trial? Okay.
My lord, may I note that at this junction, we'll be asking for cost because the third defendant had to engage counsels in this suit, and that has led to them spending a huge amount of.
They engaged counsel from the taxpayers' money, isn't it?
Yes, my lord.
The third defendant engaged counsel and paid him from the taxpayers' money.
As the court pleases.
And the claimant is one of them.
Yes, my lord.
Mm-hmm. Aja, date for trial.
My lord, I don't have the diary here, but any day, maybe January, maybe second week in January, like January 26 or 27 thereabouts.
Are you sure 26 or 27 is not weekend?
Oh, maybe it has been fused up. My lord knows I was not around for the past 2 weeks.
Yes. Okay, what you will do is, let me check the.
Maybe we should communicate the date to them later when I get to the office. So we just send them here. We just send them hearing notice next week.
Okay.
Date to be communicated later, my lord.
Okay.
My lord, I can't really get the date.
There's no date yet until next week. We'll communicate the date to you later.
All right.
Okay, okay, that is Obadibo.
Yes, yes,
That
my
is
lord.
Obadibo. And she's saying that she
Yes, my
isn't
lord.
with her. Haja is saying that she's not with her diary.
Cut that. Yes, my lord.
All right.
So when I will send you the we will have to send you the hearing
No
notice when I
problem, my
get back
lord.
to the office next week.
She'll send you the hearing notice.
No problem.
So matters are going to be communicated to
No,
council.
no problem. As the court pleases.
Thank you. Thank you, Mr. Obadibo. Mr. Adibole was discharged.
As the court pleases. Thank you.
As the court pleases.
Thank you.
And should I call the next case?
Yes.
Okay. Number NSCS/LH150/2021 between Chartered Insurance Institute of Nigeria and Mr. Emmanuel Ogenerume Emenuwe.
Parties.
What's absent, my lord?
Okay. Yes.
May the court be pleased.
Yes.
My name is Nuruddin Emmanuel.
Nuruddin.
Emmanuel. I appear with George Anyo Jongpe. George Anyo Jongpe.
Anyo
Jongpe, my lord. AYAN.
It's not ANY. Okay. AY.
Everywhere.
J.
AYAN JOMP.
The longer it is, the better for us. So that people will know the issue, they will not have all of them.
Who is that, please? Yes, for the.
Yes, we appear for the claimants, my lord.
I am Jumpe for the claimant.
He appears with me. Yes, for the claimant, sir.
Yes. Yes, Mr.
Yes, my lord. May my lord be pleased. C. Atewe for the defendant, sir.
C. Atewe.
For the defendant.
Yes. So by motion and notice dated 24th of June 2021 and filed on 25th of June 2021, the claimant praised this honorable court for the following orders. Number one, an order of Mareva injunction restraining the defendant's first respondent from selling the property located at number 10, Lamina Shuja Street, Igpuluas Estate, Ikorodu, Lagos State, pending hearing and final termination of this suit. Number two, an order mandating the defendant to submit to this honorable court the title documents of the property located at number Lamina Shuja Street, Blue Estate, Ikorodu, Lagos State, pending the hearing and final termination of this suit. Number three, an order of Mareva injunction freezing the bank account of the defendant in the second 12 respondent banks and mandating the second to 12 respondent banks to disclose the details of the defendant's account and the funds in the said account. Number four, an order of Mareva injunction freezing the bank accounts of the 13th to 18th respondent, the second to 12 respondent banks pending the hearing and termination of this suit. Number five, an order of this honorable court mandating the second to 12 respondent banks to disclose details and the amount of money in the defendant and 13 to 18 respondent banks account. Number 6, and for such further order or orders this honorable committee deemed fit to make in the circumstance. The grounds upon which the application is brought were stated on the face of the motion paper. Counsel to the claimant filed a 10-paragraph affidavit in support of the application and attached 8 exhibits. A written address to accompany the application was also filed. The applicant avowed that the defendant was employed as Director of Finance in the applicant's institute and was responsible for the control and supervision of the applicant's funds in his various bank and investment accounts. It was also avowed that the defendant's employment with the applicant was terminated due to a series of queries on his incompetence in carrying out his job. That after the defendant left the applicant employment, the applicant discovered that the defendant committed fraud by diverting the applicant's investment fund with ARM investment managers and forged statement of account and liquidity position documents to receive the applicant from knowing the extent of his fraud. Applicant stated that the defendant used his position with the applicant to defraud and swindle the applicant of around the sum of 400 million naira. It was also stated that the defendant is now at large and there is a risk that he will deplete the funds he stole from the applicant and sell the property he owns that's located in Ikorodu, Lagos State, before the applicant gets the chance to recover the funds. Final counsel in his written address raised a loan issue for termination to it, and I quote, considering that the defendant defrauded the applicant of the sum of 473,000 naira, and the fact that the applicant is now at large, it is in the interest of justice for this court to grant this application in order to give the applicant the opportunity. Submission of counsel that this court has the power to grant orders of marital injunction. Counsel refer the court to Order 20, Rule 1, and Order 22, Rule 2 of the rules of this honorable court. It is also submitted that the law is settled that the doctrine of marital injunction operates to stop a defendant against whom a plaintiff has a good arguable claim from disposing of or dissipating his assets pending the termination of the case or pending payment to the plaintiff. That the injunction can also be granted against anybody who is in possession of the defendant's asset, citing the case of Sotuminu and Ocean Steamship Nigeria Limited. While the court laid down the conditions for a grant of marital injunction, the Learned Counsel for the claimant further submitted that this court had the powers to restrain the defendant from disposing of his landed property in Ikorodu, Lagos, citing the case of Akimbola and Chairman EFCC. It was the contention of the claimant that it has satisfied all the conditions for the grant of the application and urged the court to grant the same because the defendant is at large with the applicant's funds of over 400 million naira and that there is a real and imminent risk that he's taking steps to remove his asset from the jurisdiction of this honorable court, considering the fact that he has moved his entire family to Canada. The defendants on 17th of January 2022 filed an 8-paragraph counter affidavit in opposition to the application and attached 4 exhibits. A written address was also filed thereof. The defendant stated in his counter affidavit that he did not commit any fraud or forgery and that any money transferred by him was on the authority of the applicant and for the purposes authorized by the applicant. That the property stated by the applicant in his affidavit was a joint property of the defendant and his wife, and the defendant and his wife used the said property as collateral to collect a loan which the defendant paid the claimant the sum of 20 million naira. 20 million naira. It was when the claimant reneged on the settlement between the parties that the defendant and his wife sold the property to a third party. Defendant's counsel in his written address raised two issues for determination to it. Number one, whether this honorable court has the jurisdiction to grant this application. Number two, whether this application can be granted. In response to the defendant's counter affidavit, applicant also filed a 5-paragraph further affidavit and a reply on points of law. Applicant averred in his further affidavit that the applicant's counsel was never aware of the sale and transfer of the property stated at Ikorodu before filing of the applicant's motion. The applicant is not aware that the property in Ikorodu was transferred to a third party, and that the applicant in 2021 had advertised and informed the general public that the said property was a subject of litigation pending before the court. Defendant also filed a 5-paragraph further counter affidavit, and the applicant in response to that also filed a 5-paragraph further and better affidavit on the 5th of May 2022, where it was averred among others that the defendant is still owing the applicant the sum of 400 million naira, and that the payment of 20 million naira is irrelevant. I've gone through the processes filed by the parties and the submissions of the respective counsel. I wish to observe that the applicant withdrew its prayers number 3 to 5 on its motion paper. The prayers having been withdrawn are hereby struck out, and all the arguments and submissions relating to the said prayers are accordingly discontinuous. In determining this application, I wish to refer to Order 20 of the rules of this honorable court, which states as follows, and I quote: where in any suit the subject matter on which the court has exclusive jurisdiction, the defendant or respondent with intent to obstruct or delay the execution of any decree that may be made against the defendant is about to dispose of the defendant's property or any part thereof, or remove any such property from the jurisdiction, or is founded on contrary or tort, or in which the cause of action arose within the jurisdiction, the defendant or respondent is absent from jurisdiction, or there is probable cause to believe that the defendant or respondent is evading service, and B, the defendant or respondent is beneficially entitled to any property in Nigeria in the custody or under the control of another person in Nigeria, or such person is indebted to the defendant or respondent, then in either case, the claimant may apply to the court either at the time of the instruction of the suit or at any time thereafter before final judgment to call upon the defendant or respondent to furnish sufficient security to fulfill any decree that may be made against the defendant or respondent in the suit. And of failing to give the security, open the giving of such security to direct that any property, mobile or immobile, belonging to the defendant shall be attached until the further order of the court. The application for attachment shall contain details of the property required to be attached and the estimated value thereof, so far as the claimant can reasonably ascertain, and the claimant shall, at the time of making the application, declare that to the best of the claimant's information and belief, the defendant or respondent is about to dispose of or remove the property with the intent stated in Rule 1 of this order. Number 3, where the court, after making such investigation as it may consider necessary, is satisfied that the defendant or respondent is about to dispose of or remove the defendant or respondent property with intent to obstruct or delay the execution of the decree, the court may order the defendant or respondent within a time to be fixed by the court either to furnish security in such sum as may be specified in order in the order, or to produce and place at the disposal of the court or required the said property, or the value of same or such portion thereof as may be sufficient to satisfy the decree, or to appear and show cause why the defendant or respondent should not furnish security. Unquote. The law appears settled. The doctrine of Mareva injunction operates to stop a defendant against whom a plaintiff has a good arguable claim from disposing of or dissipating his assets pending the termination of a case or pending payment to the plaintiff. The injunction can also be granted to any person who is in possession of the defendant's assets. Whatever injunction is described as a freezing injunction on the basis that the order freezes the assets of the prospective debtor pending the termination of the suit. Whatever injunction by its nature tends to prevent the injustice of the defendant taking away his property or assets from the jurisdiction of the court, which might otherwise have been able to satisfy a judgment. It is usually resorted to where the claimant will obtain judgment against the defendant for a certain sum. See the case of Drajae and Continental Feeders Nigeria Limited. See also the case of Akimbola and Chairman EFCC, where the court laid down the conditions to grant Mareva injunction as follows. Number one, that there must be a justifiable cause of action against the defendant. Number two, there must be a real and imminent risk of the defendant removing his asset from the jurisdiction. Number three, the applicant must make a full disclosure of all material facts relevant to the application. Number four, the applicant must give full particular of the assets within the jurisdiction. Number five, the balance of convenience must lie on the side of the applicant. And number six, the applicant must prepare to give an undertaking as to damages. From the avowed facts, it was stated by the applicant that after the defendant was terminated, it was discovered that the defendant committed fraud by diverting the applicant's investment fund with ARM investment managers and forged statement of account and liquidity position documents to deceive the applicant from knowing the extent of his fraud. It was also stated that the defendant is now at large and there is a risk that he would deplete the funds he stole from the applicant and sell the property he owns that is located in Ikorodu, Lagos State, before the applicant gets the chance to recover the funds. The defendant, on the other hand, stated that the property in issue is jointly owned with his wife and was sold to a third party. I wish to observe that since the defendant could use the property in issue as collateral to collect loan in order to settle part of the money alleged to have been taken from the claimant by the defendant, then I think the right person that should have been offered the property for sale was the claimant, not a third party. I observe and note that the claimant advertised to the general public that the Ikorodu property was a subject of litigation and that the defendant has moved his family to Canada. I think all these avowed facts show that the balance of convenience is in favor of the claimant. Despite that, it appears that it is true that if it appears that a debt is due and owing, and there is danger that the debtor may dispose of his asset so as to defeat it before judgment, the court has jurisdiction to grant an executory injunction to prevent the debtor from disposing of those assets. Given the facts and circumstances of this case, I think the applicant has satisfied the conditions laid down in law for the grant of this application. In the light of the above, therefore, prayers 1 and 2 of the application succeed and they are accordingly granted as spread. See the case of Shedonde, a registered trustees of Ahmadiyya movement in Nigeria. Yes.
As the court pleases.
Mr.
As the court
Nuruddin.
pleases, my lord. Yes.
My Lord,
Mr.
we are
Nuruddin is grateful.
we are grateful for the well-considered ruling of my Lord.
Yes, Mr. Atewe is also grateful. I know.
As the court pleases, my lord. As the court pleases.
Yes. So Mr. Nuruddin, what do you do?
Yes, my Lord, we shall be applying for a trial date, my Lord. Subject to the convenience of the court. We may be guided by the diary of my Lord.
Well, I believe, as my Lord has earlier pointed out, the registrar has earlier pointed out, yeah, she's not with her diary. So we'll take it that the further date will be communicated, sir.
Yes.
Okay. So case is adjourned to a date to be communicated to council.
Of the court places.
As court pleases, my lord.
As the
Yes.
court pleases.
Ajay, is there any other thing?
As far as I know, that's all for the day, my lord. Unless if my lord wants to add another thing.
No. I don't think so.
Okay.
So Mr. Nureni and George and Mr. Atchoway, that will be all for today. I wish you a very good afternoon.
Thank you, my lord.
Thank you, my lord.
Thank you, my Lord. Thank you, my Lord.
And you have a nice weekend.
Thank you, my
Yes, also, my Lord. We appreciate, sir.
My lord is here.
So see you next time and bye-bye. Thank you.
Bye,
Most
sir.
grateful, my lord.
Bye, sir.
Thank you.